My name is Janet Gurwitch. I'm the Assistant District Attorney General for Misdemeanor Sessions Court in Knox County. I handle only domestic violence cases that are misdemeanors, and I only work in one courtroom. To talk about prosecution of a case, we really need to begin to talk about what happens at the arrest. An officer will take out a warrant. The officer will take out a warrant. The defendant will be in custody or be arrested shortly after that. And you will be, or victims will be listed as witnesses in the case and not be responsible for the actual prosecution of the case. You will get a subpoena for any court dates that you need to be in court. If you should move from the time of the incident, if you move within a few weeks or even 10 days or so, you need to let someone know, either with your arresting agency, KPD, or the Sheriff's Department in Knox County, or you need to let an advocate know at the Justice Center, or you need to call me at the District Attorney General's office. Those numbers are all listed on the card that you will get from the policing agency who talks to you at the scene. What happens in the prosecution, in the process for the prosecution, is that a defendant will be taken to jail. They will be given, they will be assigned a bond, amount of money that it would take them to get out of jail. That money can be either a bond or a cash payment of the amount. So let's say someone is arrested and they put a bond on them for $1,000. They may be able to get out of jail by hiring a bondsman, paying that bondsman 10% plus a little bit over for the bondsman of that bond and get out of jail. Or they may put up the whole amount and get out of jail. Many defendants, however, do not have the money or the resources to put up that bond, so they will stay in jail. The first thing that will happen for them will be probably the next day or the next couple of days after the arrest, depending if it's a weekend or a weekday. They will come to court for their jail arraignment. Now, those people who bond out of jail will get a date for their bonded arraignment, which will be about 7 days after their arrest. The arraignment is the time that the defendant comes to court. The judge tells them what they're charged with, asks them if they understand what the charges are, explains to the defendants what their rights are in terms of their right to an attorney, their right to take a case to a trial and be heard in front of a jury. They'll be given all those rights that they are entitled to under the law. In addition, for domestic violence defendants, they're also told about the conditions that they may be facing when they do get out of jail and before the court preliminary hearing date or the next court date. Many of our cases, I would say almost all of them, require the defendant not to have any trouble with the victim. Most of them require that the defendant have no contact with them. They require the defendant leave the residence and not go back to the residence unless they have police authority to go back with them to get their belongings, but they can't live in the residence. The judge will explain those conditions to the defendant at their arraignment, and they will also ask the defendant if they have a handgun carry permit. If a defendant in a domestic violence case has a handgun carry permit, they will be required to turn that permit over until the case is done. And after that, depending on what happens with the case, after that they may or may not be eligible for that handgun carry permit again. But that is sort of an extenuating condition. At the arraignment, as I said, the defendant will have an opportunity to ask for a court-appointed attorney or tell the judge that they are going to hire an attorney or that they prefer to deal with the case on their own without an attorney. For some defendants who are in jail, they will want to talk with me that day and try to work out an agreement because they will know that they're not going to get out of jail right away and they'll want to get their case done right away. In many of those cases, if that defendant doesn't believe that they're guilty, a guilty plea will not be taken from them. They will be required to stay in jail the 10 days or so that it takes to get a preliminary hearing underway. If you know your defendant is in jail for more than 12 hours after their arrest, you should check with the clerk of courts or with our office at the Attorney General's office to see when that case is set for preliminary hearing, because that case may be set 10 days after the arrest, and you want to know that so that you can be in court. Those close court dates often, for those close court dates, the 10-day dates, we often don't get subpoenas out in time for victims to get them, and so that makes it hard for them to know when to be in court. Now, when you get a subpoena, it says on there, this is a court order. You're expected to be in court on this day for this defendant, and to discuss your case with the prosecutor. I know that's a scary proposition for many people, but I will tell you that the case will be resolved much more to your liking if you come to court. I am not, as a misdemeanor prosecutor, I am not particularly interested in having people stay in jail. As a matter of fact, for most misdemeanor cases, unless a defendant is already on probation for another matter or for another charge, they are not likely to spend any more time in jail than they would if they get bonded out, or if we have a 10-day, and then they get out of jail, whatever we do on that 10-day, most likely. But what we are interested in doing is talking with you, talking with the person who has been victimized in these situations, and finding out what we can do as prosecutors and as advocates to help you stay safe, to help your family be safe, and to give you as much as we can in terms of support and information towards that safety. That's really the most important thing. The other thing is that we also want to know, are there some other issues underlying this violence? Is the defendant addicted to drugs, alcohol? Thus, does the defendant have a psychiatric problem for which we can give them advice about where to go or where to get assistance in that? We are looking to provide as much of an opportunity for the defendant to get better, if those are the issues, as we are to looking to make sure you are safe, because we know that will stop, is important for trying to get to a point where there is no violence. One of the other things that we're really concerned with is there a power and control relationship here? Does one person control the other person either by emotional behavior or by physical violence? And we want to talk with you about that, and we have some advice that we can give you about how to stay safe, even if you stay in the relationship. We will ask the defendant, in many cases, to go to what we call batterer's intervention, men's group as we call it, in order to address those issues that they may have with relationship violence. But often the most important thing to safety is that you understand, or a victim understands, how to recognize when those changes are happening in the relationship, and you can be safe even if you choose to stay in the relationship. We have at court, I will be in court every day, or another prosecutor will be taking my place. Almost every day in court, we have an advocate who will talk with victims and witnesses about safety and about the cycle of violence and about how whether or not this situation is more lethal than you might recognize. We want to provide you with that information, as I've said, because that makes you safe and that makes your family safe. Do not stay away from court because the defendant says stay away. Do not stay away from court if a defendant or the defendant's family or cousins or friends tell you to stay away. First of all, The first day you come to court is likely the day that we will resolve this case, and you'll never have to come back to court again. And it's expensive to come to court, and we don't want anybody to have extra expenses that they have to deal with simply because they're afraid to come. The other piece of that is we tell defendants, people who are arrested all the time, your case will not be dismissed on that first court date, and if we believe that there is continuing danger, it may not be dismissed on the second court date because just because the victim doesn't come to court. We may keep a case open for more than a half a year in order to make sure that there's an open case protecting the victim. But the best way to protect yourself is to come to court. We would like to have the opportunity to talk to you. That information is going to be your best bet for safety and for moving towards your future.